realize that everyone's still getting their food, but we need to get started because the floor leader gave us a shortened time schedule. So I'm going to be moving the meeting quickly, and hopefully, if we can get everything done today, then we may not have to come back tomorrow. But we do have plans to come back after session tomorrow if we cannot get it done today. So with that, please call the roll.
Representatives Burlison, Elmer,
Here.
Allen, Anderson,
Here.
Brown, Carpenter,
Here.
Cornejo,
Present.
Breaker,
Here.
Frame, Franklin, Frederick, Hinson, Heaney, Kratky, Land,
Here.
Lichtenegger,
Here.
Mayfield, McCann-Beatty, Moon, Munsell, Nichols,
Present.
Peters,
Present.
Rhodes,
Here.
Swan, Swearingen, Walton Gray.
We now hear testimony, and Representative, whenever you are ready to go.
Thank you, Mr. Chairman, members of the committee. What you have before you today that I'm presenting is House Bill 1771. This deals with some proposed changes to Chapter 327, and that is the chapter dealing with architects, landscape architects, professional engineers, and professional surveyors. What this primarily consists of is some cleanup language and streamlining of the operation for the board and the regulations of these professions from the professional side. I had members of the board that comprises surveyors and engineers and architects that came to me, and as well as Senator Wasson over on the other side, and talked to us about some changes in here. And you can see them in the bills, rather lengthy, but there's a lot of stuff like you'll notice landscape architect is given a clearer definition. We also have added before that professional. So you've got professional landscape architecture, and you'll see several inserts in there with the word professional, which is helping further define the role of a landscape architect. We have gone through and redefined, added a couple of additional definitions in there. There's some stuff with design coordinator, design survey, and incidental practice is kind of probably the most substantial that I notice in there. What that's doing is trying to further clarify so that we can tell whenever there's someone out there practicing without a license when they should be prosecuted or held liable for practicing without this professional license. And incidental practice, this is something that goes across disciplines. So you can have let's say you've got some sort of professional engineer out there, they're doing, let's say, site work for a project, and they design a trash enclosure. Well, that might actually be a structure, and that could arguably fall underneath needing architectural design or some other form of engineering. And that's not the intent, is to punish someone or hold them accountable for practicing outside of where they're licensed to practice. That's just kind of incidental practice, which is defined as secondary and substantially less in scope and magnitude than what is in their usual scope of practice. So we wanted to define that so that kind of clarifies some of the issues with the board. We also have underneath here, we've had an issue where we've had vacancies on the board in different areas, and they have not been reappointed. And we've had some of these where we've got people sitting in those positions that have agreed to go on sitting on the board for years after that they should have stepped down and would like to have stepped down, but they need to fill a vacancy, or they have a vacancy that has been there for a substantial amount of time. So what this has gone through, and it's trying to identify ways that those positions can be filled, because the governor is not taking action on filling those positions. And these aren't the types of positions that they have big salaries with them. We've adjusted if the members of the board have to appear for a day and they're devoted to the board's activities, we've changed this to be from $50 a day to $75 a day. So, the governor not appointing someone, I assume that there's probably not as many people standing in line, but there are people that we think could fill these positions. We would just like to have them filled so that the regulation of these professions can occur. And so what we've done in here is we've addressed that issue with who can appoint that and taking some of that authority away from the governor's office, which I imagine that they'll object to, but we're trying to remedy a situation here rather than let it continue on due to lack of attention. I would like to point out on page 14, we've got some language in here that I will be presenting a House Committee substitute that will be taking it out. When we originally drafted this, it dealt with expert testimony and lawsuits, and it's something that got added in this version. We didn't really intend for it to be in, and the parties involved, we've all talked about it on each side, and everybody's kind of agreed that that needs to come out. So right now, I have the intention of filing a House Committee substitute. I didn't have it ready for you today, but it'll take that specific language out with reference to expert testimony, and I know that like MATA was going to have an issue with that. They may still speak on that, but it's the intention that we're going to resolve that issue. The rest of this is just, like I said, it's basically streamlining, tweaking things so that the regulation and control of these professions can be better handled by the board. With that, I'll yield to any questions.
Questions for this testimony, Representative McCambey? Proceed.
Just a couple quick questions. Having served on a commission, I do understand how difficult it is to get people to serve, and I'll have to agree with you that getting those appointments done has been a bit of a challenge, probably in many professions. But I did have a question. I always get concerned when we put a specific organization in there. And I don't know this, is there any other organization, you've got the American Institute of Architects, is there any other organizations out there?
Well, you have differing boards and stuff, but I can tell you as a licensed architect that the AIA is the overarching professional organization. And within the state, they have a state organization, so what we're talking about is the president. And it changes from year to year. They elect their president, and it's a licensed architect within the state. And, you know, I'm comfortable as an architect knowing the past presidents that have been and the current one, and I think that they're probably best situated to really figure out who could fill that professional position. But as far as another professional organization on par with that, the architecture, I don't think that there is one.
That was my concern. Like in appraising, there are actually 5 or 6 national organizations, so I never like to name a specific organization in legislation.
Well, and you'll see in here, like under the licensing requirements, like there's the American Institute of Architects, which is a professional organization, and then they have the National Council of Architectural Registration Boards, call it NCAR. And that is a licensing, they have an intern development program, and that's something recognized in all the states. So, you know, on the licensing side, it's good to identify them in here because they are the standard. The NCAR was in existence whenever I was going through my licensing process. I'm NCAR certified whenever I went through it, and that's all recognized. So I'm comfortable putting that in, but I can understand in other professions where you can have competing interests, but I don't, that's not occurring here.
Okay. Thank you.
Representative Lichtenegger.
To inquire.
Proceed.
Basically, this bill is simply defining your rules and regulations, you know, about the board.
Well, yes. I mean, it's doing that, you know, giving them mechanisms to fill these positions, trying to streamline this. I mean, we want this is a bureaucracy. I mean, let's call it what it is. And we want it to operate as efficiently as possible, and that's the intent of this bill.
Will this save money within the Department of Professional Reg?
I do not know.
I mean, will they be able to consolidate a little bit more, or are they pretty consolidated right now?
I think they're pretty consolidated. I can tell you whenever I first got my architectural license, I think and I paid a fee every other year. It was like $150. I paid it last year, it's $35.
Oh,
so,
wow.
you know,
Pretty consolidated.
yeah, as they've done that, and they've done a good job with that. Now,
I guess I was going after the representative's question, and I was curious about that. So it is really in this state. You know, you're doing what we're doing in this state, not nationally.
Right, yes. And that's what we're addressing within these boards.
All right, thank you.
Are there any other questions for this witness? Seeing none, we'll now hear testimony in favor.
I would, if I could, I'd like to call someone up that could testify for informational purposes only. And that might help fill in some more gaps for the members feel like, Mr. Chairman.
That's fine.
Judy Kemker, if she's here. And she's just testified for informational purposes only. I want to clarify that.
Hi, good afternoon, Chair and committee members. My name is Judy Kemper. I'm the Executive Director for the Missouri Board of Architects, Professional Engineers, Professional Land Surveyors, and Landscape Architects. Like Representative Hellman said, this is mostly a housekeeping bill. The statute, Chapter 327, has not had a major overhaul since, I believe, 1969. The practice definitions of architecture, engineering, land surveying, and landscape architecture, those, however, are not housekeeping, but some of those have not been changed since 1969. But through the years, the standard of practice has changed. So the revisions in this bill reflect those changes and are also very similar to the definitions that are being used by our sister boards in the other 49 states. In addition, most of our exams, and soon to be all of our exams, will be computerized. These are national exams that are given, and so therefore the national organizations mandate when and how they're given. So because of that, our application processing and administration procedures have changed, and the revisions in this statute will reflect our modern day practice. If you have any questions, I'll be glad to answer them.
Thank you for your testimony. Are there any questions for this witness? Seeing none, thank you for taking time to testify. Is there anyone who wishes to testify in favor? Please come forward.
Mr. Chairman, members of the committee, my name is Kathy Harness, and I am a registered lobbyist here on behalf of the American Institute of Architects of Missouri, and we want to go on record in support of this language. I know the committee on the board, which is comprised of 3 architects, 4 engineers, 3 landscape architects, and 3 land surveyors. They have worked over the last 2.5 years to on this language to reach a consensus among themselves, and it's not an expansion of scope. It's really just a clarification of a lot of issues that have come up since there have been changes to this section.
Thank you. Are there any questions for this witness? Seeing none, thank you for your time.
Good afternoon, Mr. Chairman. My name is Richard Barr. I'm a licensed land surveyor and licensed professional engineer. Today I'm representing the Missouri Society of Professional Surveyors, and we're in favor of this. I can also mention I am a former board member, registration board, and I agree with the changes they're making.
Thank you for your testimony. Are there any questions for this witness? Seeing none.
Mr. Chairman, my name is Mark Rhodes. I appear on behalf of the Missouri Society of Professional Engineers. We're in support of this and have worked carefully with the other professions to come to an agreement. Be happy to answer any questions.
Thank you, Mr. Rhodes.
Thank you.
Are there any questions for this witness? Seeing none.
Mr. Chairman, members of the committee, Sam McLeod for the Missouri Association of Landscape Architects in support of the bill.
Thank you for your testimony. Any questions for this witness? Seeing none, thank you. Are there anyone else who wishes to testify in favor of House Bill 1771?
Mr. Chairman, my name is Bruce Hillis. I'm in support of this regulation or this bill with one caveat, and that caveat is in 327-381. The original legislation or the original statute provides grandfather clauses for anyone that when they increase the licensure requirements, education, definitions, etc. And that existed as well for reciprocity, for people coming in from out of state. If people coming in from out of state met the qualifications at the time the license requirement were established, they would continue to be grandfathered, or they could be accepted. However, this bill eliminates that grandfather provision for out-of-state applicants, which in my view, one of my principles of advocacy is that it reduces competition, and for that reason, I will be opposed to that provision of the bill.
So you're in favor of the bill, but against that specific
Yes,
provision?
yes.
Okay. Are there any questions for this witness? Seeing none, thank you for your testimony. Is there anyone else who wishes to speak in favor of House Bill 1771? Seeing none, is there anyone here who wishes to speak against House Bill 1771?
Good afternoon, Jim Durham on behalf of the Missouri Land Title Association. And we're only opposed or have a problem with one section of the bill. That's 327.272. And our concern is twofold. One is we've added as one of the things that a surveyor can exclusively do is the preparation of a legal description. Using that language worries us because our agents are constantly preparing legal descriptions. Every time you do a deed of trust, anything like that. I think that's something we've talked about before, and I believe maybe can resolve. The other new item.
Please speak into the microphone.
The other new item that's been added to the bill from years past is saying that surveyors are the only ones who can survey and establish right-of-way and easements. And I can assure you that that actually involves the practice of law. The actual document that's prepared has only a legal description on it, but the document itself is something that should be done only by attorneys. The other concern we have in this is that in a later subsection in, that I've just lost, in subsection 2 of that section, I believe it is, these things are identified as something that can be done only by a surveyor. I think possibly if we just change the numbering in that subsection to show that these are things that surveyors do, but that also may be done by other people as well, that may resolve the problem. And I'll try to answer any questions.
Yes, Representative Frank. Proceed.
Has the sponsor shown any willingness to compromise on these issues?
We have just begun talking about it. Frankly,
Do we work it out?
we're aware of this.
Okay. So we look forward to just negotiations going through.
Yeah.
Okay, great, thanks.
Representative Fraker.
To inquire, Mr. Chairman.
Proceed.
Would those issues be able to be resolved before we exec this out of committee? This question might be for the sponsor.
Yes, I mean, obviously, we'll be working on this before next week.
Okay, great.
Thank you. Thank you, Mr. Chairman.
Thank you. Representative Mayfield, did you have a question? Okay. Are there any other questions for this witness? Seeing none, thank you for your testimony. Is there anyone else who wishes to testify against House Bill 1771? Seeing none, that anyone here wishes to testify for informational purposes? Seeing none, that ends the hearing on House Bill 1771.
Next, we will move on to House Bill 1824, sponsored by the Chairman, Burlison. And we'll let him proceed whenever he's ready.
See if we can make this happen. Anytime you use modern technology, there's always an opportunity for failure. However, All right. Thank you, Mr. Chairman and members of the committee. For the record, my name is Eric Burlison. I represent the 133rd District, Springfield, and the town of Battlefield. And this bill essentially establishes a non-binding guideline for regulation of occupations and professions that are not regulated by the Division of Professional Registration within the Department of Insurance and Financial Institutions. We often hear new ideas, new licensure laws that come to this committee. And so I thought I'd show a short video that I think is pretty educational and that kind of establishes, and I want to stress that this video is talking about professions and licensing that is not, that's not necessarily medical. So let me see if I can get this sound to work here.
It's called occupational licensing, and a new national report released by the Institute for Justice shows just how widespread and costly it has become. In the 1950s, only 1 in 20 workers needed a government license to work. Today, it's 1 in 3. To get a license to work, the government forces you to clear one hurdle after another. Education or training, passing tests, paying fees, and more. Too often, these hurdles take time and money to jump. They make it harder and harder for people to find jobs and to build new businesses that create jobs. How much harder? To find out, we examined licensing laws for 102 occupations in all 50 states and the District of Columbia. We looked only at low and moderate income jobs like interior designers, massage therapists, and shampooers, not doctors or lawyers. On average, these licenses require you to pay $209, pass an exam, and complete more than 275 days or about 9 months of training and experience. 1/3 of these licenses take 1, 2, or even as many as 6 full years to earn. That's a lot of time and effort spent getting permission to work instead of working. And we haven't even talked about costs, like tuition for required schooling. Which states are the worst for licensing? Louisiana licenses the most lower income occupations at 71. Hawaii has the highest hurdles. And the very worst states for would-be workers have a lot of licenses and high hurdles. Arizona leads that list, followed by California, Oregon, Nevada, Arkansas, Hawaii, Florida, and Louisiana. In those 8 states, it takes an average of 1.5 years of training, an exam, and more than $300 in fees to get a license. Unfortunately, research provides little evidence that government licensing like this makes the goods and services you buy any safer or better. Instead, it raises costs for consumers and reduces opportunities for workers. We found at least 4 other reasons to doubt that many of these hurdles are necessary. First, some licenses simply don't make sense. Should you really need a license to shampoo hair, be an interior designer, or work as a funeral attendant? Second, the vast majority of jobs we study are done in one state or another without licensing. Shampooers are licensed in only 5 states, interior designers in only 3 states in D.C., and funeral attendants in a mere 9 states. The question is, what's happening in states not licensing these jobs? It's hard to believe there is a dangerous epidemic of shampooing in 46 states. Licenses like these should probably be scrapped. Third, licensing requirements are often wildly inconsistent from one state to another. Take manicurists. 10 states require at least 4 months of training, but Iowa requires only 9 days. Alaska, just 3. Do manicurists in, say, Alabama and Oregon really need so much more training? Lowering hurdles like these would make it easier for more people to find work and create jobs for others. Fourth, the difficulty of jumping licensing hurdles often has little to do with the safety risk of the job. The hardest occupation to enter in our study is interior designer. It takes 6 years of education and training, plus an exam and fees, all for a harmless occupation that is practiced safely in 47 states without licensing. Compare that to emergency medical technicians, who quite literally hold lives in their hands. Yet, 66 other occupations have heavier licensure burdens than EMTs, including landscape workers, manicurists, and a host of contractor designations. The average EMT spends about a month in training and takes 2 exams. The average cosmetologist spends about a year, more than 10 times the training of an EMT. This doesn't mean that EMTs should face higher hurdles. Other occupations should face lower hurdles, or none at all. Licensing may have little to do with protecting public health and safety, but it does protect those who already have licenses from competition. Raising barriers keeps new competitors out and prices high. If state lawmakers want to help more people find jobs, they should start by clearing away licensing barriers that do little more than protect some people from competition by keeping others out of work. Discover more at ij.org.
So it's an interesting video. I'm not proposing that we eliminate any licensure in this bill. So just to clarify. But what I thought that it was a good video to get started the discussion. How do I escape that? There we go. Which is that we often hear many suggested changes to our licensing laws, and I believe that we should certainly pay a lot of attention to the laws related to the low-income licensing, because those seem to be the ones that are affected the most. And we have a study that was done by the Obama administration recently that showed that the cost of licensing nationally in the form of lost jobs is between 0.5% and 1%. So what that's saying, it applies to Missouri. That study showed that Missouri Missouri would gain approximately 15,000 jobs if, based on the 15,000 workers are not being employed because of licensing laws. So, what this bill that we're looking at today is not eliminating any licensure laws. It provides a framework for the creation of new ones. As you saw in the video, Missouri is actually not highlighted as a state that has over-restricted ones. It's not one that is mentioned. So what this bill does is it provides a guideline for us as lawmakers to ask the right questions, because most of the licensure, the times that we have licensure being created, much of it is really the same issues, same requirements on education, same morality clauses, and so where this bill came about is, I'll give you an idea that last year, Representative Mollendorf presented a bill that I thought was a very thoughtful way to approach some of the mandates we often see in the insurance committee. And what he created was what was called a Sunrise Act. He said, before we make decisions such as this, that because we do know that they have impact on the cost of health insurance, and often we hear both sides talk about what these costs are, and we don't really know what the true numbers are. So he wanted to have an actuarial study done before the committee can thoughtfully address what the true costs are. And I think that played out this year. Where the bill that has been not moving for many years, in fact, for almost a decade, is the bill related to the pharmaceutical industry, the chemotherapy drug bill. But that, because of the actuarial study that was done in that bill, it gave the committee a great deal more information that we could trust and rely on. So with that in mind, I looked, and my staff found that other states have put in place, in fact 20 states have passed this legislation in conjunction with what's called the Sunset Act. So what other states are saying is that when you're creating a licensure law, we should at least examine some of these questions that are listed in this bill. But if and then the other states, they have a sunset provision that says every so many years the legislature, these licensure, this certification or registration will expire unless they can go back and prove that it still needs to be in place, going back through the same steps. This bill does not have any sunset provision. So in essence, this bill creates, I think, a very modest framework that asks the questions that we expect of people when they want to create a licensure or add more onerous scope to their existing licensure. And so with that, I'd be happy to entertain any questions on the bill.
Any questions for Mr. Chairman?
To inquire. Okay. The chairman asked me if I would fill out his questions, and so I did. And I found them really interesting, Mr. Chairman. And they were not easy questions to answer, but I did it as if we were going to license a new dental hygienist practitioner or a new dental therapist, which are two ideas that have been talked about for my particular profession. And I will be glad to share these with all of you, the answers to my questions. But as I went through, a lot of the questions, for me, being an auxiliary person within the dental field, as this would be an auxiliary person within the dental field, a lot of these answers would be answered through the Missouri State Dental Board, which is under the Division of Professional Registration and Licensing, and the scope of practice would come from that after this was tasked for these two professions to be done. And so I covered, that the education has to be there, the proper license has to be required, the proper CE credits, continuing education credits have to be required. And every 3 years, we would have to go through and we would have to say, this is our scope of practice, and we would be under a collaborative practice of a dentist, and so forth and so on. So I really like Representative Burlison's bill. It really made me think about how this profession would proceed with a licensing. It talks about, this bill really talks about why would this bill, or why would this profession have to be under the Dental Board of Professional Registration and Licensing as far as the welfare of the patient. And I think that's a very important question, or not just the welfare of a patient, but the welfare of our constituents. I thought that was a really good question. I really had to think about some of those answers. I think if each of you went through this for your individual professions, I think that you would find these answers are questions that we should need to answer within our own professions, and I really liked it. And after I finished answering all these questions, I told him this today, I really wish we had the sunset on it. I realize that the sunset may be something that we need to look at later on, but I certainly think that in all of our professions that it would be good, it would literally make us every 5 or 6 years, whatever the sunset would be, to go back through our divisions, our boards, and look at that scope of practice and say, do we need to change anything? Or do we need to make this better? Do we need to make this more clear to the public? Or, as Representative Burlison said, do we need this? So those are just some of the thoughts I had about this as I looked through it. But like I said, the main thing, besides making me think about my own profession, was the sunset part of it. Because it really makes the boards, all of the boards, and all of the divisions within the professional registration and licensing, it would make them go over all of those rules and regulations that all of our professions have to live by. Thank you.
Thank you, Representative Tenayer. Representative Frank? Who produced that video we just watched?
That was the Institute for Justice. I found it online.
Okay. I saw some initials at the very end. I didn't recognize them at all, and it kind of felt like it was a witness testifying, but we weren't allowed to ask questions. So I was looking at their name, Institute for Justice.
Right.
Anything about them at all?
They are a think tank.
Okay, great. Thank you. Here, sir.
Any other questions? Representative Carpenter?
Clark?
See?
I
this bill, Mr. Chairman. I like the spirit of it, at least. I've got a question as to our ability, sort of to hamper the future actions of a future legislature. Have you given some thoughts about how it would pertain to that? I mean, obviously, this is not a constitutional change, right? So this isn't.
And honestly, it's not binding. It really would be something that would be at the discretion. There would be nothing to stop a committee from considering a bill and passing it. This would not force them to go through this.
Okay. So, like, it says you're going to do a continuing education requirement on a job, then you'd have to prove with evidence that that is actually necessary. But that's really more, so that would be more of like a guideline. That's what they ought to do,
right.
If they were going to do a continuing education requirement.
Right. And rather than just have it for the sake of having it, I think it should be, before we require people to go through some, I mean, it would be for the committee to consider. If the association can, if they're going to have put it in statute or require that people do it, then if the committee wants to ask a question or have that, they would then have that information before we to make a thoughtful consideration.
Thank you.
Thank you.
Questions for the bill sponsor? Seeing none. Those who wish to testify in support of House Bill 1824, please come forward.
Next, Mr. Chairman, I have someone to testify in favor that is remote, and so I'd like to allow him to testify. I'm trying to do a lot of technical things to this. We'll see if this works.
I think your computer guy.
Can you hear us?
Boys and their toys.
Okay. Yeah, we can. It would help if I was connected to the projector.
I'm afraid I can't hear you if you're talking to me.
We'll get you that.
Okay, we can. All right, we're ready, if you can hear us.
Okay, well, shall I proceed, although I can't hear you?
Yes.
My name is Timothy Sandifer. I'm an attorney at the Pacific Legal Foundation in Sacramento, California, although I'm speaking to you from Phoenix right now. And I am the author of the book, The Right to Earn a Living, Economic Freedom and the Law, which is a constitutional and legal discussion of economic liberty and how it relates to the Constitution. Occupational licensing is one of the severest restrictions on the constitutional right of every person to earn a living without unreasonable about spikes and no questions about pigeons. It gets even worse because the law only applied if you were dealing with pigeons. If you were dealing with any other kind of bird, say seagulls or something, you did not need any license at all. Well, as testimony in this lawsuit proceeded, it turned out that the reason for this law was because those licensed pest control workers did not want competition against them. And so when the proposal was floated to limit the licensing law, those who already had licenses said, no, we want to keep control over the pigeon exclusion trade because that's the most common trade when it comes to bird exclusion. So that's just an example. By the way, we won that case, and the Ninth Circuit struck down the law saying that the government is not allowed to use occupational licensing simply to protect insiders against fair competition. Licensing laws that restrict economic competition harm the poor the most. The people who are harmed most by licensing laws are those who can't afford the required education and training elements of a licensing permit, or can't afford to travel to the place where the exam is offered. A lot of the time, to get a license, you have to pass a test, and these tests are sometimes offered only once or twice a year, sometimes in places that are very far from where, poor people who need an entry-level job, often it's hard for them to get there. Sometimes there are multiple-day exams that require a person to stay overnight in a hotel room, for example. Licensing laws are also very often subjective and allow the government entity to deny or withhold licenses on the basis of subjective attitudes. For example, Louisiana has a law that requires a license if you want to be a florist. And until recently, you had to pass an exam that tested the beauty of your floral designs before you could get a license to be a florist. Now that hasn't
Love the IT department here. All right. All right, with that,
Okay, seeing there's no questions for this witness.
Thank you.
Do you have other testimony that you want to call or open it up? Yes. We'll now take testimony in support of House Bill 1824.
It's okay. I'll be short. My name is Jeff Howell. I represent the State Medical Association. We think this is an innovative way to keep me from having to testify in front of you every week. I haven't seen the sub. I was a little concerned about how some things were worded, but we're working with the sponsor and the committee to get something done. So, I'd be answering questions.
Questions for this witness? None? Thank you. The witness is in support of House Bill 1824.
Mr. Chairman, my name is Bruce Hillis, and I'm proud to testify in support of Representative Burlison's House Bill 1824. I won't be redundant on any testimony, or try not to be, but of all the principles on which I advocate against restrictive occupational licensing, I think the most important one of those principles is that occupational licensing should be the least restrictive possible. And there's some real reasons for having the least restrictive occupation regulations possible. Not that occupational regulations aren't often needed, but they should be justified as a compelling interest, but they should be the least restrictive. And the reason, the more restrictive, that's not justified based on protecting the general welfare of the public, the more restrictive they are, the higher the cost. Professor Morris Kleiner of Minnesota indicated in an economic study that occupational licensing versus just an alternative of certification added 15% to the cost of those services. So the more restrictive the occupational licensing is in relationship to what it needs to be to protect the public welfare, the higher the cost. Also, the more restrictive that an occupational licensing is in relationship to what it needs to be to meet the protection of the general welfare of the citizens of Missouri, the more restrictive it is on employment. Professor Kleiner, and I think you heard him mentioned by the sponsor here, indicated that if if you didn't have these low-level occupational licensing in Missouri, it produced some 15,000 jobs. Let me just draw a real comparison of two occupational regulated groups and see if you can see, I'm sure you'll see the distinction between how restrictive one is and what it can do to jobs and cost, and how unrestricted the other group is. And this is not certification or registration in this category compared to licensing. These are two licensed groups. Those two groups that I'd like to talk about just briefly with you is accountants and cosmetologists. One of those is not very restrictive at all.